is Jennifer Bragar, and I think I'm actually introducing Kate today. And I wanted to say that yesterday we kicked off this conference with enthusiasm and energy, and our terrific speakers have more than met our expectations, with today's sessions tying together many of the points raised yesterday and by our keynote speaker, Richard Rothstein. I want to once again thank all of the people on the Willamette Law Review and Housing Land Advocates Board who made this conference happen. I am now pleased to introduce Kate Walz, a senior staff attorney at the National Housing Law Project, who will offer closing remarks. Kate is a national expert on federally assisted housing preservation, fair housing, crime-free and nuisance property ordinances, the Violence Against Women Act, and the intersection of the criminal legal system and housing access. She has extensive housing policy experience and has also served as counsel in several high-impact litigation cases and HUD fair housing complaints. So I'll turn it over to you, Kate. Thank you so much.
Thank you, Jennifer, and thank you for the opportunity to speak. Perfect, thank you. So discriminatory zoning and land use regulations create abundant opportunities for dominant white forces in a community to exclude new housing development and Black and brown residents. And they've been doing exactly that for more than a century in the United States. They can also result in starkly different life outcomes for people living in BIPOC communities, where the only investments in their neighborhood are industrial pollution or other harmful land uses, or the clustering of affordable housing. What I will talk to you about today is the particular history of Chicago and the work that I've done with 10 grassroots community-based organizations to challenge it. So in Chicago, exclusionary housing policies come not only from the city's racist history of blocking public housing, which is well documented in Professor Rothstein's book, The Color of Law, and keeping that public housing out of white neighborhoods and clustering it in Black and Latinx neighborhoods, but from its deep commitment to hyper-local control over land use and zoning. This has resulted in a deeply fragmented city, where the city's 50 wards and council members have reinforced structural inequalities and further marginalized Black and Latinx residents, to the point that where the city has lost since the 1980s a full quarter of its Black population. So what is aldermanic prerogative? It is the power of council members to maintain control over their wards, primarily by initiating or blocking city council or city governmental actions, particularly as it relates to zoning and access to affordable housing dollars, city lots, and the like, and permitting. A former alderman, Joe Moore, said he likened it essentially to a feudal system, where the mayor is a sort of de facto king and the aldermen and alderwomen are the ladies and gentlemen of the ward, but they're each with their own fiefdom. Segregation in Chicago, like all parts of the United States, was essentially engineered by public policy, starting with policy from the federal government. In Chicago, as was detailed in the Gautreaux litigation that's still going on today, aldermen were allowed to decide where public housing was built. So public housing was built almost exclusively in Black and Latinx neighborhoods. What public housing was built in white neighborhoods was only for white families. And they really maintained the racial boundaries of the city of Chicago. This is a quote from a former alderman, Reginald Dubois. "We all want to protect our homes, and the people of this community will put up a stout fight." Alderman Dubois said this on the eve of literally taking to the streets with his constituents to block Black families from moving into a white ward in Chicago. But today, little has changed. Aldermanic prerogative maintains that same fragmented power, and it is a one-sided system. So aldermen that want to capitulate to the demands of their constituents and block affordable housing are green-lighted with their ability to do so. These two photos are from an incident a few years ago where an affordable housing developer was trying to build affordable housing in the neighborhood of Jefferson Park, which is on the north side of the city of Chicago, where many of Chicago's firefighters and police officers live. It's a predominantly white neighborhood of single-family homes. In the photo to the right, you can see it says Cabrini started as vet housing. That is, of course, in reference to one of the more known public housing developments in the country, Cabrini Green. That was more than 15,000 units of public housing. This was a 44-unit affordable housing development for veterans with children. And they were opposing it, and their alderman wanted to use his power of aldermanic prerogative to actually support the development and give them the zoning change that they needed. This was a perfect example of how the system is one-sided, because then Mayor Emanuel deferred to what the constituents were saying and urged the aldermen to side with the constituents, even when they were making explicit racial stereotypes and dog whistles about the potential residents of that development. So when aldermen want to block affordable housing, the city backs it. The city says that it is legal, that they are deferring to what neighborhoods want in their communities to preserve the character of those communities. When aldermen and constituents want to actually invite affordable housing into the communities to advance racial integration or to protect against gentrification and displacement, they are told, wait a minute, hold on, we're not sure if you have the power to do this. So what are the impacts of aldermanic prerogative? Just 20% of the city's land is actually zoned for multifamily affordable housing. And as a result, most of our affordable housing is clustered in Black and Latinx neighborhoods. And over the last 25 years, over half of Chicago's 50 wards did not accept a single unit of multifamily affordable housing. 27 wards have not accepted a single unit of multifamily affordable housing. What we see then is a real imbalance in affordable housing development throughout the city, increasing rents. We have a ban on rent control in our state as well, a real loss of population of Black and Brown communities, African Americans in particular, and a decrease of support for local businesses. What are the tools of aldermanic prerogative? First, the most powerful tool is unfettered zoning power of each alderman. And it stems initially from what we have in predominantly white wards of the city of Chicago, what we call zoning advisory councils. So these are advisory councils made up of constituents of the ward. They are typically white homeowners who, when the developer has a request for a zoning change, they most first go before the zoning advisory council. In some cases, what this has caused over the years is developers know those zoning advisory councils are ZACs that will simply not approve affordable housing in those white wards. And so they do not apply to those wards. They do not put together an application or even attempt to build affordable housing. So then again, it furthers the clustering of our affordable housing in the city. If a developer is willing to go forward with the zoning advisory council, they may be subjected to multiple community meetings that often become more and more volatile and racist in nature. They may be told it cannot be family affordable housing, it has to be only for seniors. They may be told that they have to limit the number of units or the number of bedroom sizes, again, to avoid families with children. And what we see is that the power of these ZACs is most predominant in the white north and northwest wards, or those pockets of white communities on the south and southwest side of Chicago. Those communities that are more mixed or predominantly African American, if they have a zoning advisory council, they are there actually to have a real conversation, a real community conversation with developers about what they need, what their desires are, and how they can create more balanced development within the city. We also see the power that the alderman holds on their own to downzone lots and to landmark. So for landmarking, they're really using it as a tool to limit density and affordability and to preserve white neighborhoods. So even in properties or areas of the city that are not architecturally significant, we're talking architecture from the 1980s and 90s in many cases, aldermen have almost an unfettered right to landmark that area to really limit what can happen in terms of tearing down a building to create affordable housing or increasing density to create affordable housing. For downzoning, what we see is that aldermen are able to preemptively downzone so that they'll force that developer to go before the Zoning Advisory Council. This is Alderman Napolitano, who's done the most downzoning within the city. He represents the Jefferson Park district that I mentioned previously. And he preemptively downzoned a whole swath of Jefferson Park after nearby developments tried to be built in the ward adjacent to him. And in an email to his constituents, he said, "My priority to you as alderman is to put your interest above all else." We do have within the city of Chicago an inclusionary housing ordinance. There are ways, however, that the developers can essentially buy out of the inclusionary housing ordinance. So there are not strict limits on the size of units that they build. They can build for sale units in addition to rental units, and they can put into the city fund an in lieu of fee. And so again, what we see is this essential pipeline of those requests to use inclusionary housing where there's a zoning change, that they're routed through the zoning advisory councils. And yet again, the zoning advisory councils with the alderman's support or even without the alderman's support are then saying it cannot be family housing, it must be for sale housing, they must be studios or one-bedroom apartments. So they're really able to limit the availability of family units being developed through the ARO. And then we have access to city funds. And we've had a recent success with this, but for the last several decades, in order to apply for housing and community development funds through the city of Chicago, you had to have a letter of support from the local alderman where the property would be built. If you could not get the letter of support, your application was incomplete. And so you could not even have an opportunity to be fairly considered for that project. Aldermen were using this power not only just to essentially pocket veto affordable housing developments, but to dictate the terms of when they would allow affordable housing to be built in their wards. So yet again, we would see where they would say, I will offer the letter of support if it's for seniors only. I will offer the letter of support if you do affordable condos versus affordable rental. I will offer the letter of support if you can get my constituents to back you, which of course they never would in the majority white wards. So what we saw from that was that 90% of the multifamily affordable housing was built outside of white and predominantly low poverty areas. And that 27 wards, as I said before, did not accept a single unit of multifamily affordable housing. Senior housing, on the other hand, fared far better. So 65% of the senior affordable housing built with the city's dollars was in white and low poverty areas. Alderman, oh, let me step back for a second. So I did say that there was a recent success with this. With all of this information, on behalf of 10 grassroots community-based organizations who had been fighting for years to create fair and affordable housing opportunities throughout the city, came together to really challenge Aldermanic Prerogative. And it first started with a report called A City Fragmented, but ultimately resulted in a fair housing complaint filed with HUD's Office of Fair Housing and Equal Opportunity. When Chicago got a new mayor, Mayor Lightfoot, one of the first things that she did agree to do was to remove the letter of support requirement. And so developers can fairly apply for these funds without having to first get permission from the local alderman. So there's control of city-owned lots. Aldermen still have power over all of the lots in their ward, and they can essentially earmark parcels of land and remove them from the land inventory. So even if it's an available lot, they can remove it from the land inventory and hold it for their own purpose. This really gives an infinite amount of power over what opportunities there will or will not be within their wards. And we found through our research that there was no city-owned parcel in predominantly white areas that has been used to build a single affordable housing dwelling unit outside of the units that were built as a result of the Gautreaux Decree. There's also what we call parliamentary and extra parliamentary powers. If a developer is lucky enough to get through the Zoning Advisory Council to actually have the alderman move forward with a request for the zoning change, they still have to get through the committee on zoning and then through the full city council. And so what aldermen will do, and their colleagues will defer, is that they will ask for a deferral of the request for the zoning change. And so this is an email that was sent to the chairman from Alderman Napolitano, who I mentioned before, who was asking for an indefinite defer of the amended plan development at 8535 West Higgins. Essentially, these projects die on the vine. And for nonprofit developers, they do not have the time and resources to overcome this. Even for the for-profit developers we talked to, it was easier to just go to those wards who were willing to accept affordable housing than to deal with the type of shenanigans that they saw there. And even with the aldermen who are allies to the community organizations that I represent and want and invite fair and affordable housing in their wards, they will defer to what the aldermen want in their individual wards. So what are our recommendations? First, the city of Chicago lacks a comprehensive plan, as shocking as that may be for the size of city that we have. So the city of Chicago has not had a comprehensive plan since the first Black mayor, Harold Washington, in the 1980s. So we're asking the city for the first time to implement a citywide comprehensive plan. But as the foundation for that is something that we saw from King County in Washington, which is a racial equity impact assessment of Chicago's neighborhoods. And to accompany that, action plans for each of those neighborhoods to overcome those impediments. And we want this to be part of an engagement process with the community. One of the speakers before talked about really the importance of those most directly impacted by these policies being at the center of decision making. And that's our goal here, is that they are actually actively involved as part of the impact assessment and the action planning. We also see a key need for a centralization of zoning to remove it from this fragmented 50 ward nature, and real transparency and accountability. We need to assure that the city's housing and community development funds are being used in a way that is equitable and that is leading to opportunities for affordable housing in all areas of the city of Chicago, as well as an equitable investment in those communities that have long been neglected. We need a strengthening of our inclusionary zoning laws that have sort of allowed these numerous exit doors for both developers and aldermen and white neighborhoods to avoid obligations to create affordable housing. We'd like a citywide policy and plan for city-owned lots, particularly in white areas. And then we are pushing for a comprehensive curriculum to be developed that would both go to the city council and city staff, but also to our Chicago public schools to talk about Chicago's history of residential segregation and the causes of that and the continuing effects of that today. I'll leave you with one last thing. Heather McGee's new book, The Sum of Us, examines the hidden cost of racism for all of us and how it impacts society as a whole. So it is on all of us to push for equitable housing policies. Thank you.
Thank you, Kate. Kate gave her closing remarks for the symposium, so thank you again, Kate, for closing us out. I want to thank the Housing Land Advocates for helping host the symposium with the Willamette Law Review. We could not have organized this event without their aid. We really appreciated working with them. To answer some questions I've been getting, all attendees will be receiving a post-symposium email, which will include information about where to find the recording from these 2 days. So I want to thank you again. Thank you to the attendees and to the panelists and to the moderators who all volunteered a lot of their time over these past 2 days and before generating material to put this together. This was a really interesting event, and I hope that it was both educational and thought-provoking for you. I was very pleased with the mixture of people attending, and I was just stunned by the quality of the presentations. So thank you again. Thank you for attending, and I hope that you all have a great weekend. Thank you.